Welcome to Diagnosing Health Care, a podcast featuring thought-provoking conversations about the latest legal, policy, and regulatory issues in healthcare and life sciences. While these issues may seem like hurdles, we'll also look at the business opportunities and solutions that exist. Diagnosing Healthcare is brought to you by the lawyers at Epstein Becker Green, a leading law firm that has decades of experience serving clients in the healthcare and life sciences industries nationwide.
Today on Diagnosing Healthcare, we will discuss physician ordering and specimen collection considerations for direct access laboratory testing stakeholders. Hello and welcome. I'm your host, Megan Robertson. I'm an attorney in Epstein Becker Green's healthcare and life sciences practice based out of our Washington, D.C. office. There's a complex landscape of state laws that overlay the direct access testing model, from physician order requirements, including telemedicine standards and the corporate practice of medicine doctrine, to specimen collection considerations, including how the varying options for collection could impact a model. Today, we're going to cover those factors, both on an independent basis, as well as how they combine to create a roadmap for those companies that are navigating the direct access testing industry. Today, on our third episode of the Direct Access Laboratory Testing series, we are exploring the state requirements governing the physician orders for lab tests in a direct access testing model, as well as factors to consider when stakeholders are deciding on a specimen collection method for their model. If you like what you hear today, please subscribe to the show. Diagnosing Healthcare is available wherever you get your podcasts. Joining our discussion today is Amy Lerman. Amy is a member of the firm at EBG in our DC office. Amy advises clients on a wide range of matters involving government investigations, audits, and related claims of fraud, false claims, and other non-compliant behaviors. Amy also advises telehealth clients on trends and the development of regulatory strategies for growing and expanding telehealth businesses. Welcome, Amy, and thank you so much for joining us.
Thank you so much for including me in today's discussion.
Also returning to the podcast today for this series is Bob Hearn. For more than 20 years, Bob has dedicated a significant part of his practice to working with clinical laboratories on a wide array of legal issues impacting lab operations. He routinely assists with structuring business relationships between laboratories and hospitals, as well as physician practices that comply with federal and state anti-kickback, self-referral, anti-markup, and direct billing laws and policies. Bob also possesses extensive experience with state and federal surprise billing statutes and the application of consumer protection laws, such as the FDCPA and its state counterparts, as well as patient billing by healthcare providers. Bob, thanks for joining us again on this third episode of our special series on direct access lab testing.
Thanks, Megan. Glad to be back.
So let's start by talking about physician orders. In previous episodes, we have referenced the concept that direct access testing models often incorporate a requirement that all tests must be submitted by an authorized physician, and that the definition of an authorized physician and the extent to which they need to be involved with a patient before being able to order a test varies from state to state. So this could stem from a state requirement, from reimbursement strategies for the direct access testing to show medical necessity, or from the desire to avoid the test being classified by FDA as a direct-to-consumer test, which could subject the test to heightened FDA scrutiny. So once a business reaches that decision, saying, yes, I want to require a physician order for my test, what's next? How do they go about doing that? Amy?
Megan, it's a great question. The most immediate steps in the process, from my perspective, depend at least in part on how far of a geographic reach the business wants to be able to offer these tests to customers, patients. If we assume, as many businesses do ultimately decide to do, that the reach is going to be nationwide within the U.S., state requirements pertaining to both the clinical practice, in other words, evaluating patients and the ordering of the tests, but also the structure of how the physician network is set up need to be considered. On the issues pertaining to the clinical practice, at some level, we can't avoid a state-by-state analysis, as you said. Different states have different requirements. But on the issues pertaining to how the business is structured, the most common approach that we see clients taking is the use of the friendly PC clinician networks, which businesses can either build or they can buy. We'll get a little bit more into detail, I know, on the friendly PC concept in a moment, but let's focus for now on the build versus buy decision point. There are some really strong advantages to building your own clinician network. For example, specialized nature of the clinical services to be provided, which could, in this case, in this example, include the ordering of tests, the control over how the network gets built, how it operates, how the services are offered, how it's all managed. But there are significant legal and regulatory issues to managing the network as it gets built and then as it operates. It's certainly doable, but for not an insignificant legal and regulatory compliance undertaking for an organization by any means. By contrast, overall growth within the telemedicine industry over, let's say, the last decade has given us some incredibly efficient options to buy access to a clinician network. That is, to contract with a third-party entity, one that's often been built for this exact purpose, to allow telemedicine businesses and other types of businesses to operate without building their own clinician networks to get that national reach, because the third party has done the work and they can contract with the business for use of those networks.
Thanks, Amy. So if a business were to decide to engage in this process of actually engaging a physician network, let's go further into that analysis. One thing that we've addressed is that, say, a business creates its own professional corporation, its own PC, and engages a telehealth provider or a network of providers to order tests that way, then could that trigger issues in states that prohibit the corporate practice of medicine? How does that impact a company's strategy for where to offer services initially, and then how they would expand into other states over time?
Well, so this is the build decision. And if a business is choosing to build its own clinician network, the first hurdle that the business needs to clear is this question, as you've noted, of how the complete operation is structured. The corporate practice of medicine is a prohibition on non-licensed individuals owning or controlling professional medical practices. Applicable laws live in a lot of different places when we talk about corporate practice, or CPOM as we refer to it. They could be in state-level licensure rules, entity formation requirements, professional practice rules, sometimes in opinions or guidance from state attorneys general or state licensure boards. They're all over the place. And states vary, even in the states that have the prohibitions, like just even within that group of states, because not every state has them, but at least half do. But they vary in their degrees of CPOM scrutiny and enforcement. So compliance with state corporate practice rules tends to come, as I had mentioned earlier, in the form of these friendly or captive PC setups. They work to maintain a separation between the professionals and the non-clinical administrative operations of the business. And the whole point of the friendly PC structure is to ensure, staying consistent with CPOM requirements in the states where they do exist, really that the independence of that clinical decision-making, the work that the physicians are doing, can always be maintained. And the way it works at a high level, a friendly PC structure, is there is a professional entity formed. It could be a professional corporation, a PLLC, some sort of professional entity. That was going to be owned by a quote-unquote friendly professional, which in our example, let's just say is a physician. Separately, a non-professional entity, most often a C corporation, but other corporate forms work in other instances as well, that exists to carry out the non-clinical aspects of the business. It's referred to as a management services organization, or an MSO. The professional entity and the management entity are aligned through a management services agreement. The agreement outlines each party's responsibilities. And basically, as the corporate practice rules work, the MSA, the agreement, will dictate that the MSO is responsible for the business decisions and other non-clinical decisions, while the professional entity keeps control and responsibility over all the clinical decisions. And the two entities do work together, and MSAs often and should recognize that. But they also recognize that the two entities exist as separate and distinct legal entities that have separate and distinct responsibilities and authority. But as I mentioned, not every state prohibits the corporate practice of medicine. About half the states do, and others do not. So telemedicine businesses have to consider where CPOM compliance is going to be an issue, where it may not be an issue. And that does, again, kind of revert us back to needing to develop a state-by-state strategy as businesses look to build this national network. And telemedicine businesses have done this in various ways. Also, just as a side note, within the group of states where CPOM compliance is an issue, you have to not just look at the rules that apply to the corporate entity and how that has to be formed, but also to rules that may exist as to who can own the professional entity, whether those individuals have to hold licenses to practice in the specific state, also whether the professional entity must be formed in the state or if foreign qualification of an entity formed in a different state will suffice, because it does in many states. There's only 3 states that really say it must be formed in my state. So a lot of considerations. Again, it's a layered set of decisions that a business has to make as they decide, in this instance, how to build what they want to build.
Absolutely. And I think one point I want to hit on is it doesn't have to be an all or nothing model, right?
Yeah.
Like you said, you can build over time. It can be a strategy of what states do we want to operate in first, and then whether or not we want to grow over time. Is that your observation?
It's encouraged, in fact. It's difficult. Even when you think about some of the largest telemedicine companies in the country, they may exist in current form as these large nationwide footprints of care provision, but many of them started as very small operations, starting in a state or a handful of states, and have grown that way over time. And to get the nationwide presence that they ultimately sought, I think it helps to spread out the decision making, to see how the business operates state to state, because certainly when you roll over into some of the more clinical aspects of providing the care across different states have different rules related to including ordering of tests. So you get that chance to experience the growing pains with a group of 5 states or 10 states rather than jumping headfirst into 50. There are also cost considerations to operating in 5 or 10 states versus 50 states. So always my advice to start small, see how things fit, and then the strategy can be to grow ultimately to your national presence over time.
Yeah, and I think it could also be interesting from an investor, a potential investor's perspective as well, to, looking at a smaller company, like you said, to see whether they have that sort of plan in place, even if they started small, like thinking ahead and looking at that growth option for sure. So moving into more of the telemedicine focus, because that's the other piece here, right? If the direct access testing company were to contract with this existing network of third-party licensed providers, presumably that contracted network would already comply with modality and licensing requirements of state laws for telemedicine. But if the business wants to build its own network, it would have to track and analyze all these requirements on a state-by-state basis in-house. Is that right?
Indeed. It carries a lot of responsibility when a business decides to build instead of to buy. We've been talking really more about the structure and corporate practice and the rules around that, but you're absolutely right that the clinical network, once it's been structured properly, it has to operate compliantly. And that goes to your point, Megan, that state-by-state tracking of the requirements for the actual provision of telemedicine services, physicians, and separately any other types of licensed professionals who may be part of the care regime. That has to be tracked, and it does go state by state. And the requirements, while you will start to see patterns and consistency across states in terms of how they treat the requirements, there's not a clear and safe way to make assumptions that just because one state says these are the rules, you can assume that those rules apply in the next state or the next 10 states for that matter.
Thank you, Amy. There's one other concept I want to cover on the physician ordering side, and that is really at the sort of the end of the testing process when the results come in, and that's returning of the results by the ordering physician to the patient, and whether face-to-face consult or telemedicine consult is needed, really thinking about whether that's necessary as far as supporting medical necessity for the test, particularly for diagnostic tests versus screening tests. So thinking about that, Bob, did you have any thoughts on the importance of considering whether or not the results will be returned to the patient ultimately?
It's an issue I think that you have to think about on the front end, even though it relates to the sort of tail end of a laboratory's work, and that is the reporting of the test. So thanks to changes to CLIA more or less a decade ago now, patients have access to their test results that they didn't have before those amendments were implemented. I think what that causes people to conclude is, well, if we're going to provide a direct-to-consumer style test to patients that has to be ordered by a physician, all we need is someone to order it, right? The question then ultimately becomes in the end is, well, am I going to give the patient's test result not only to the patient who's entitled to it, but am I also going to give it to the ordering physician? And what role does the ordering physician then have or obligation do they have with regard to counseling the patient about what those results mean? So you have to think about that, I think, on the front end. It could impact a lot of different things. It could impact the cost of the services that you essentially buy or a lab buys from a contract telemedicine or telehealth provider, because they may want to charge more for consulting with the patient about the meaning of the test results. And then, as you alluded to, the counseling that the ordering provider gives to a patient may impact a third-party payer's perception of the medical necessity of the lab service at issue. Think about it, right? I mean, if a lab test gets initiated by a patient, you plug them into a physician that then orders the test, and the results are delivered to and picked up by the patient, it's very difficult for anyone to track and document whether the lab results provided anybody with any clinically actionable information. To the extent that you're going to seek reimbursement from a third-party payer that's going to analyze medical necessity and require the lab or the ordering provider to have information in their files showing that the test was in fact medically necessary, you probably need to think and require some interaction between the patient and the ordering physician after the test reports are delivered. And the best way to assure that is by delivering the results back to the ordering physician. This also creates issues for labs that want to offer incredibly specialized tests to patients or to allow patients to order those types of tests on their own. If you tap into the sort of pre-existing telemedicine networks, a lot of times their providers don't have the specialized level of expertise that's required to analyze the types of testing that a specialized laboratory may want to deliver. But I think the issue still is whether there needs to be some interaction between the patient and the ordering physician, even if it's in the form of referring the patient to a specialist. So it may be that you also want to think about having a specialist network in the background for analyzing your lab test in the event that that becomes necessary as well.
Definitely. So we've been talking a lot about the physician ordering of the test. Let's turn to the other concept of our episode, which is what happens once that order is submitted and it's time for the patient to submit their sample. Bob, what are some of the options out there for specimen collection?
Right. And I feel like I've got such an easier piece to deal with than Amy did on this. It's complicated, but it tends to be more practical because specimen collection is remarkably lightly regulated. It's one of the few areas in lab-related practice that is not heavily regulated at a state or federal level. So there are really a few options for specimen collection if you are going to offer a patient-initiated testing product. Which method a lab uses depends on multiple factors. Really, the primary one is the type of specimen required to perform the test and the level of skill and oversight required to collect the specimen. Do you need blood? Do you need saliva? Do you need a fecal sample? How difficult is it for a patient with no training to extract these types of specimens from their person? There are a few general options for specimen collection. There's patient collection at home. There's contracting with existing labs with extensive PSC networks who can collect the specimen on a contract basis. There are mobile phlebotomy providers and specimen collection providers who you can contract with that will actually make house calls to collect different types of specimens from patients who have initiated a lab test. And then there's the build-it-yourself model, analogous to the physician build-it-yourself network that Amy talked about. You can actually start a network of draw collection stations that are capable of collecting whatever specimen it is that you think is necessary to drive your testing.
Yeah, and I'll throw another wrinkle in, which, is if as part of the model, a business wants to provide a convenience kit. So maybe there's not a perfect product out there on the market for the specimen collection, and they want to put a couple of different products together in one container or box. And a convenience kit is generally considered to have just a bunch of legally marketed products or FDA cleared products and their original labeling and intended to be used consistent with their legal intended use, that's another factor of consideration, right? How is that convenience kit going to be labeled? Does it need FDA approval before it's sent out? Just another factor to throw in for consideration by companies.
Yeah, for sure. I mean, there are a lot of regulatory issues associated. I say it's relatively simple. There are regulatory issues associated with the manner in which specimens are collected. I know we're going to sort of delve into those more deeply in the next episode of our podcast, but just to give a sort of a high level overview, you've hit on one for sure. If you were going to provide a collection kit to a patient for self-collection at home, by and large, those collection kits have to be FDA approved. There may be some softness when you have these convenience kits that you're talking about, but by and large, you're talking about needing to have FDA approval or clearance for the devices that get sent to a person for home use. When you contract with a mobile phlebotomy provider, you need to make sure that their phlebotomists are appropriately trained and licensed in states where that's required. There's only a handful of states that require phlebotomy licensure, but you got to make sure that if you're going to collect in those states, that they're using folks who meet the requirements. And you also need to think about whether the vans or units that the mobile phlebotomy providers drive to a person's house, and which are often used as the actual situs as opposed to the living room of the patient for the specimen collection, whether those are appropriately licensed. There are some states that require mobile phlebotomy licensure for the actual unit or the van or bus that's being used. And there are some states that are even more restrictive with regard to non-laboratories being able to collect specimens, like New York. So there are some things to think about here. We're going to get into that in a deeper level in the next episode.
For sure. So we've touched primarily on state level factors today. In addition to, obviously there are some federal regulatory requirements that overlap with those. What tips would you give stakeholders when faced with this complicated web of regulatory requirements that can seem intimidating at first glance?
Yes. So Megan, I would say that you have to really assess all the legal and regulatory challenges posed by your direct access testing model early on. You have to understand what's required at a sort of very technical, scientific, or medical level. And you have to make sound strategic decisions about what your enterprise can manage early on in terms of complying with the regulations that control the way in which the technical mandates of your lab test are executed. You have to think about whether you can work with an existing physician network to screen your patients and order tests. Amy and I have worked together on these issues a lot, and we've talked to several entities and folks lately who come in with a grand plan to start their own physician network, and they pretty quickly realize that that's a little more work than they're prepared for, either logistically or financially. So you need to understand what you're getting yourself into on the front end, both economically, technically, and also with regard to the regulatory environment that you're wading into.
I guess I'd add, and we kind of touched on this earlier, that even if nationwide presence is that ultimate goal, giving serious thought to starting smaller, a single state, a group of states, to test out a business model under a more controlled set of these legal and regulatory requirements, because they can feel daunting because there's just a lot to keep track of. Whether a business decides to build or buy, there's just a lot of these details that the business needs to consider, certainly more so if they're building their own, but they have to really weigh as a business decision what the pros and the cons are of building their own versus buying. And I see positives and negatives on both sides. But to start small allows you to see where, for your particular business, the most significant challenges may arise. It gives you a bit more latitude to figure out the best strategy for working through them and to go from there before you run out of time, effort, money, whatever the constricting factors may be for a business, and to have a smart decision-making process before jumping in too deeply.
Well, thank you both so much for joining us today for such a great discussion. And a special thanks, as always, to our listeners. I'm your host, Megan Robertson. If you like what you've heard today, please don't forget to subscribe. Diagnosing Health Care is available wherever you get your podcasts.
thank you for listening to Diagnosing Health Care. For show notes on today's episode, additional episodes, and more insights on trending issues in healthcare and life sciences, please visit diagnosinghealthcare.com and be sure to subscribe on your preferred platform. This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.